Okay, we've talked about the different kinds of trademarks, how some are distinctive when they're born, and some become distinctive over time, and some are just never going to be able to be trademarks. So we have our inherently distinctive marks, our descriptive marks, and our loser marks. Now, I'd like to talk to you about one other important aspect of trademark law, which is priority. Basically, priority is how you establish your trademark rights. Once you've decided on a good trademark, you need to establish your rights through that. So, what is priority? Well, priority is basically like waiting in line. The person who gets there first gets more than the person who gets there last, because they might run out. And that's exactly how it is in trademark law, is we deal with different levels of priority. So in trademark law language, the prior user, the one at the front of the line, can prevent later users from using trademarks that are confusingly similar. So if you're the first one to use a particular trademark, then you have priority over somebody else who wants to use the exact same trademark or a similar trademark on a similar type of good. Now, if you've ever been to the airport, you know that there are lines and there are lines. Not all lines are the same. Some people have to wait in one line, or some people have to wait in another line. And furthermore, what you get at the end of the line varies. So, you all wait in line to go through security. Some of you are going to end up in first class. Some of you are going to end up in coach, regardless of where you were in the line. Same thing with trademark law. We have basically a hierarchy of priority. At the top of that hierarchy is what we call common law trademark rights. Basically, where you haven't filed a registration for the trademark, a federal registration for the trademark. I'm going to leave out state registration because, for the most part, state registration does little for you with respect to priority. So we're going to focus on federal registration versus not registering federally. So you do get some rights by using the trademark, but they're not as good as what you get when you register on the principal register. So when I talk about common law priority, I'm talking about, okay, I've been using the trademark, but I haven't registered it on the principal register. When I'm talking about federal priority, I'm talking about, okay, I have registered the trademark on the principal register of the USPTO. Now you might notice, if you're particularly astute, that there's part of this triangle missing. There's another thing called the supplemental register, which is also federal, and you can register on the supplemental register. The thing of it is, it doesn't give you a whole lot. It's kind of like coach plus benefits. Well, not even plus benefits, coach plus an extra drink or something, I don't know, plus a meal. You get a little bit more, but really registering on the supplemental register doesn't give you the major benefits that come from registering on the principal register. So when I talk about registering and I talk about something being registered or not being registered, what I'm referring to is the principal register. I'm not referring to the supplemental register. Okay, so we've got two kinds of priority, as I already discussed. First, we've got common law priority. Common law priority gives you priority only in the geographic area where you've used the mark and the natural area of expansion around there. So if I've used the trademark in Phoenix, then I have rights in Phoenix. But somebody else can open up a store with the exact same name in Albuquerque, and I don't have priority there. That's common law priority. Federal priority, and we're talking about the principal register, is much sweeter. It's nationwide. So if I've registered my trademark on the principal register, it doesn't matter that I haven't sold any products in Albuquerque. I still have priority there, as long as I filed my federal registration before that other person got common law rights. So, how do you get priority? And we'll come back to that common law federal priority issue in a couple minutes. But how do you get priority? Do you have to register your mark to get priority? Well, the answer is no, because as we've just seen, you can get common law priority without registering. Still a very good idea to register the mark. And again, I'm talking about federal registration, not state. Do you have to register the mark to sue for infringement? Well, with copyright law, that's a jurisdictional prerequisite. And with patent law, well, you have to have a patent. With trademark, nah. The Lanham Act allows infringement actions based on common law priority. You don't need to register for that. Okay, so how do you get common law priority? Well, if you have an inherently distinctive mark, you get common law priority by using the mark. That's it. You have to use it enough that people recognize it as reflecting your good or service. If it's a non-distinctive mark, priority starts on the day that you gain secondary meaning. Now, it's not like lightning comes down from the sky and you hear a thundering voice saying, today is secondary meaning for your trademark. It's a guess, and it's something that gets litigated. When did you actually establish secondary meaning? And you have to bring evidence of what advertising you've done and how the trademark is being used in publications and such to show that, okay, when people hear this word, they're thinking of my trademark and not it in the descriptive sense. What about on the federal side? How do you get federal priority? Well, again, you have to distinguish whether it's an inherently distinct mark or a non-distinctive mark. If it's inherently distinct, you get your priority date begins upon registering the mark on the principal register. So I could start using my mark on Monday and register on the principal register on Friday. And if it's an inherently distinct mark, my common law priority date will be Monday and my federal priority date will be Friday. But what about if it's a non-distinct mark? Well, then you can't register on the principal register unless you've gotten secondary meaning. So your priority is going to start when you obtain secondary meaning. Okay, so why bother? Why not just use your common law priority? Why bother getting registered on the principal register? It takes time, it costs money, it doesn't cost that much, but it takes time, and a lot of people do not register their trademarks. They wait to see if they're going to, if the business is going to go, if the trademark's going to take. And then once their trademark's valuable, then they go and they try and register it. And that's not a good idea for some reasons that I hope will become apparent in a second. So the first big benefit of registering on the principal register is you get priority nationwide in the class of product. So if I open up Brigham's ice cream store in Phoenix and I use the trademark in interstate commerce and I get a federal registration, I have priority across the nation in that class of good. Now somebody else could use my name to sell something else as long as it's not going to be confusingly similar to mine, as long as consumers aren't going to be confused. But it gives you a nationwide priority. Let's spell out this example. So let's say, here's a map of the U.S. Sorry, I left off Alaska and Hawaii, but they're on here too in our minds. Let's say I open up Brigham's ice cream store out there. That looks like somewhere around Cape Cod, Connecticut, Boston, somewhere around there. And I start selling ice cream, and things are going well. And actually, let's say it's not Brigham's ice cream store because that's descriptive. Let's say it's an inherently distinct mark, like the Majuga ice cream store. So I'm selling under the name of Majuga ice cream store. Now I've got a sister, let's say, who lives in California, and she says, hey, I want to open one up too. And so we work together, and she opens up one in California, and she's selling under the Majuga ice cream store name. Well, after some time using our trademarks, then we've established some protection. We've got protection in the geographic area where we've used it. So nobody else in the Boston area can come and open a Majuga ice cream store restaurant, or in Southern California. But let's say there's some guy in Florida who wants to open up Majuga's ice cream store. And what he does is he files a federal trademark registration. And he uses the mark across state lines, or he gets an intent to use, which we'll talk about in just a second. Where does he have priority? Well, we were there first, so we used the mark first. So where does he have priority? Everywhere we haven't used the mark. Look at that. He's got tons of priority, even though we were there first. That's the benefit of registering on the principal register, is you have priority nationwide everywhere that the mark that somebody hasn't already established common law priority. Okay, some other benefits. In litigation, your trademark will be presumed valid if it's been registered. Basically what that does is it puts the burden of proof on the defendant, the person challenging the mark, to say, hey, that trademark's not valid, it should have never been registered. Customs will bar imports, which is convenient. You can get treble damages in intentional infringing case and attorney's fees in exceptional cases. If it sits on the principal register for 5 years without being challenged, then it gains incontestable status. And basically an incontestable mark cannot be challenged as invalid, although it can still be argued to be weak or generic or functional or abandoned. So it gives you some staying power, although not a complete shield. So, getting federal registration. What kind of marks can you register on the principal register? Well, we've talked about inherently distinct marks and non-distinct marks. Inherently distinct marks you register on the principal register. Non-distinct marks you would have to register on the supplemental register. So, in order to register the mark, you have to show that you've used the mark in commerce. Well, what does that mean? Well, if you've taken con law, you know that that probably means across state lines or in some other way affecting interstate commerce. It's conceivable for somebody to have in fact this happens quite a bit, where somebody has a restaurant or a bed or breakfast that's only in one state. But if they're gathering people from out of state who fly in state to stay there or to go to that restaurant, or they're getting national publicity, then that can be interstate commerce. So basically, in-commerce means across state lines. But there's an exception to this. You don't have to show use of the trademark if you want to file what's called an intent to use application. Basically, you get to say, hey, I want to reserve my priority, reserve my spot in line for this particular trademark. And so you file your trademark before you've even used it. And within 6 months, you need to file an affidavit saying, okay, now I've used the trademark in commerce. And you can actually get extensions up to 3 years to use the trademark. So it can give you priority without really using the mark. So it can be that's a great benefit. Just a couple comments on the supplemental register. If you register something on the supplemental register, it can be moved to the principal register once it acquires secondary meaning, which basically is the same as if you hadn't registered it on the supplemental register. there's also an assumption that if it's sat on the supplemental register for 5 years, then it's going to be assumed to have obtained secondary meaning. So that can be helpful. For the most part, registering in the supplemental register doesn't give you a lot. So what kind of marks can't be registered? Well, let's look at the statute. Section 2 of the Lanham Act says that registration can be refused for a number of reasons. And let's go through these play by play. First, if the mark consists of or comprises immoral, deceptive, or scandalous matter, disparaging of institutions, beliefs, or national symbols. So this was evoked much more often in earlier years. Now it's fairly rare to see something dubbed scandalous so that it cannot be registered, partially because of First Amendment concerns. But if something is purely to disparage a group or to suggest a false connection or to deceive somebody, then or consumers, then it can't be registered. If it has the American flag on it, well, no, there's a lot of things that have the American flag on it, and they can still be registered, but you can't register the American flag or any other flag as your trademark. If it has an individual's name, portrait, or signature, or a deceased president of the United States. So if they're alive, not the president, if it's anybody and they're alive, you can't register their signature or their name or their portrait. So does that mean that you can't register John Doe? Well, if there's a bunch of John Does out there, then you'd be able to register it. But you're going to have to show that it's obtained secondary meaning. And then fourth, if it is already being used by somebody else and it's likely to cause confusion, well then of course you can't register. So these marks can't be registered regardless of obtaining secondary meaning. Now that's true except for C. I gave the example of John Doe. If it's a common name or something like that, then you could obtain secondary meaning. But if it's like a famous person, I could not register Barack Obama pants or Mitt Romney eyeglasses or something like that, regardless of whether they're president or not. And if it's a president, then and they're dead, then I need to get the permission of their widow. Okay, and it goes on. Then we have section E, which lists a bunch more reasons to allow refusal of registration. The first one is when it's used in connection with goods that are merely descriptive or deceptively misdescriptive. Well, we know what descriptive is. Descriptive means it describes the product or service. And we've talked some about that. You can't register something that's descriptive unless it's obtained secondary meaning. Deceptively misdescriptive is a deceptively confusing term that actually means it misdescribes the product in a way that people care about. So, for example, if I sell jeans under the name of Arizona Jeans, most people aren't going to really care that the jeans aren't made in Arizona. They're not thinking the jeans are made in Arizona. So they're not necessarily deceptively misdescriptive. I mean, they are misdescriptive to some people, but not in a way that deceives people, not in a way that people care about. If, however, I were to sell champagne that doesn't come from that area of France, and to claim it to be champagne, that would be deceptively misdescriptive. Or if I described my coffee as Colombian, and it wasn't really from Colombia, Well, people might care, hey, I want the Colombian stuff. I want the stuff that really is from Colombia, not the stuff that just tastes like it's from Colombia. Um, then the next one seems to me a little superfluous because it's the same as the one above. If it's geographically descriptive, then then you can't register it without obtaining secondary meaning. So like Phoenix School of Law. Um, when used in connection of goods, is primarily geographically deceptively misdescriptive of them. Well, again, going back to number one, that's saying the same thing as number one, where you've described something in a way that deceives people, in a way that they care about with regard to your product, saying that it comes from somewhere that it doesn't really come from, if that matters. Nobody thinks Swiss cheese only comes from Switzerland, but Roquefort cheese, they think comes from Roquefort. Primarily merely a surname. Well, basically, it's your name. It's functional. I've already talked about that. So you'll notice that some of these are ones that you can still register it as long as you can show secondary meaning. So take a look at those and decide which ones are ones that you can overcome a refusal of registration if you show that it's obtained secondary meaning. The answer is those three. So if it's descriptive or deceptively misdescriptive, but it's obtained secondary meaning, you're good to go. If it's geographically descriptive, but it's obtained secondary meaning, you can register it. And if it's merely a surname, like McDonald's, you can register it so long as it's obtained secondary meaning. The other two, it doesn't matter whether you say you've got secondary meaning or not. You can't register it. So if it's geographically deceptively misdescriptive, so it says that it's from somewhere it's not, and people care about that, then you can't register it. And if it's functional, it doesn't matter how much secondary meaning there is. It's functional. You should get a patent instead. Okay, dates to remember. The first date. Why is the date the mark was first used relevant? Well, that's the common law, geographically limited priority date for inherently distinctive marks. Why is the date the mark was registered on the principal register relevant? Well, that is the priority date, the federal nationwide priority date. Why is the date the mark obtained secondary meaning? Well, if it's a descriptive mark, then the date it obtained secondary meaning is the date that it begins to have common law priority and begins to be eligible to be filed on the principal register. The date the mark was registered on the supplemental register, as I mentioned, if it sits on the supplemental register for 5 years, then secondary meaning will be presumed, which just saves you the evidentiary burden of showing that your descriptive mark has obtained secondary meaning. Okay, now let's see if you've learned anything. I've given each of you a hypothetical about Rainbow Jewelry, a place opened up that sells jewelry. Sometimes with rainbows, sometimes without. And this chart shows the dates that the various important events happened. So go on to Twin, and there's a quiz there that you can use to answer the questions for that to see if you've got priority correct. and there will be explanations along with the answers, whether you get them right or wrong. And then after you've done that, move on to part 2, which is trademark registration formalities.